My duty is simply to introduce the two principal contributors to tonight's paper. But I want to say one or two preliminary words about the auspices under which this is taking place. This is a collaborative venture, originally sponsored by the trustees of the Worth Library and the Long Room Hub, together with a number of other institutions in Dublin whose names are listed on the programme in your folder. And we're doing this partly at the instigation or with the encouragement of Nicholas Mackey to commemorate his father, who was a colleague of mine many years ago, Bill Mackey, research librarian in this college. A man who taught me a great deal and whose memory I think is important at this moment when questions of academic freedom, of freedom of inquiry, and so on, are under subtle but very considerable pressure. I won't delay you with accounts of the various splendidly comic incidents of Bill Mackey's life, including the possible encounter with Wittgenstein, but simply say that I'm honoured to have in our presence tonight, we're honoured of Nicholas Mackey's presence as the principal sponsor of the occasion. He and his family have been extraordinarily supportive in advancing this project. We, with his assistance, are offering a program of 7 lectures, some of them taking place in Trinity, next week in UCD, one in the National Library of Ireland, some in the Worth Library, and I would ask you to look at the program and follow some of those through. I'd like to introduce our chair for this evening, trustee of the Worth Library, Dr. Emer Lawler, a hematologist in St. James Hospital, and a major figure in the complex medical and ethical and administrative world of modern medicine. You'll find details of her career and her engagements in the brochure that I've already referred to. I will then leave it to her to introduce our speaker.
Well, I think it's very fitting that the first in the series of the Mackey lectures coordinated by the Worth Library considers the legal position of medical and scientific research in relation to the great imperatives of freedom of expression and information. The Worth Library constitutes, and it was described by Chief Justice Ronan Keane, as the private library of a man of taste and learning at the flood tide of the Enlightenment. I think that's beautiful. When a man of learning's library was expected to contain a range of contemporary human knowledge which allowed discussion and correspondence on scientific and philosophical matters among members of the Republic of Letters, irrespective of their backgrounds. And of course, this was before the schism between the humanities and the sciences developed, which has often led to the two sides to treat each other with mutual distrust. And of course, that can only be to the detriment of society as knowledge grows by cross-fertilization of disciplines. So lectures like these can help bridge that chasm. And I have great pleasure in introducing James Hamilton to you, who, as you I'm sure know, is the Director of Public Prosecutions in the state. He is a graduate of this university in history and political science in 1971. He was called to the bar and practiced at on the Northern and Dublin circuits, and then became prosecuting counsel for County Donegal until he, in 1981, when he was appointed a full-time legal advisor to the Attorney General of Ireland. And in 1995, he became permanent head of the Office of the Attorney General and senior legal advisor to the Attorney General, and was a member of the Constitutional Review Group, which published a comprehensive review of the Constitution of Ireland in 1996, and I think he will be referring to that in his lecture. And he is a member of the Council of Europe's Commission for Democracy, and has written on a great number of legal issues. So I think he has a wide view of both the situation in relation to research and freedom of information, both in Ireland but also globally. And great pleasure in asking him to come and take the podium.
Thank you, Dr. Lawler, for your very kind introduction. I've been asking myself, well, really other people have been asking me, why are you giving this lecture on this subject? And the truthful answer is that Bill McCormick 3 months ago asked me would I give a lecture, and I said yes. What did he want me to lecture about? And he told me, and it sounded like an interesting subject. I've been regretting it ever since. I had no idea what a wealth of stuff there was out there, how much reading would be involved, but nonetheless my initial thought that it was an interesting subject was confirmed, I think. I'm not going to talk about freedom of expression in the sense that it's used, FOI, the way in which one can get information from government or not, as the case might be. That's not really my concern. But to come back to, my main concern is the question of freedom of inquiry, by which I'm talking principally about scientific and medical research. The reason for that is that they're the areas where there's most controversy and most interest. On the face of it, you might say, has this got anything to do with criminal law? And at first glance it doesn't look as if it has much to do with it. But actually that's not in fact so, because the original impetus for looking at the whole area of medical research and what were the limits of it and so on was the doctors' trial at Nuremberg after the Second World War, where 24 doctors were put on trial for war crimes involving experimentation on human beings. And of the 24, 8 of them were acquitted, but 6 of them were sentenced to death and subsequently executed. And during the course of that trial, attempts were made to argue that there were no core principles of ethics that applied universally, that there were simply different rules that applied in different places. And that view was refuted by expert witnesses, and effectively what they said became the core of what were known as the Nuremberg principles, and which I'm going to be talking about that and about the way that has developed over the years. Of course, things that freedom of expression, that's not my principal subject, but insofar as it relates in very closely to freedom of inquiry, I'm going to say a little about it. Again, the recent controversy about blasphemy shows how the criminal law again can have a relevance to freedom of expression. And indeed such issues as contempt of court, criminal libel, which one doesn't come across very much, and so forth, are relevant in that context. When one thinks of the central issue in relation to experimentation, which is really the question of not carrying out research on people without their consent, that again has major implications for criminal law, because of course if you do carry out that sort of activity without consent, you commit an assault, and you may commit endangerment, and you may even commit, as many of the Nazi doctors did, murder or very serious assaults on people. Again, if you look at some of the other issues and the obvious way in which they would be enforced, for example, we don't have a law here prohibiting human reproductive cloning, but if we did, you would expect it to create a criminal offence. That would be the normal way that one would deal with that. So while it's not part of core criminal law, it's nonetheless something that I would regard as of great interest to me. What I'm going to do is look at, in particular, scientific and medical research and the extent to which it's given effect as a legal concept, both within international human rights law and in Irish law. And as I said, I'll compare it with freedom of expression, which has given rise to a lot more litigation and analysis than freedom of inquiry. And I want to look at some similarities and differences between the two concepts. Arguably, the right to freedom of scientific research or inquiry is an aspect of freedom of expression on the basis that the right to express something is not much use if you can't find it out in the first place. And then I want to go on to look at whether there's adequate protection given to the right to carry out scientific research, both in our constitutional law and our other law, and in human rights, international human rights instruments. I'll then talk a little about the abuses which can arise through the misuse of scientific research. And as I said, that principally arises in relation to the issue of the consent of the subjects of the research. And then I want to go on to refer to areas which have been problematical in relation to scientific research, in particular protection of the human genome, human cloning, and the use of human embryos in stem cell research. And finally, I raised the question whether there's a need in this jurisdiction for further regulation in the area of biomedicine. I've tried to aim the paper at a listener who may not have special knowledge in legal concepts, so I apologise in advance to people to whom these concepts are familiar, and I hope they don't find that I'm oversimplifying things. And as I'm not a lawyer, as I am a lawyer, I'm not a scientist, maybe I'm not a lawyer. Insofar as I have to refer to scientific matters, I apologise for my imperfect lay person's grasp of complexities, but I think I know enough to understand how complex the matter is. And if there are any questions about that at the end, I think Dr. Lawler will be dealing with them rather than me. So I give her warning in advance. First of all, I want to say a little about what happens when two legal rights come into collision with one another. And this is important because very few rights can be regarded as absolute and not capable of being derogated from. One of the few exceptions to this rule is the right not to be subjected to torture, though even with regard to this, one well-known American scholar, Alan Dershowitz, wrote a book suggesting that torture should be permitted in circumstances where it could be used to obtain information which could save lives. He hasn't received much support for this from other members of the legal community. But despite this exception, most rights are not absolute, and even the most fundamental right of all, the right to life, is not unqualified, as legal systems pretty well always permit life to be taken by a person acting in necessary and proportionate self-defence. So I want to say first a little about limitations on freedom of expression. Again, most legal systems give extensive protection to freedom of expression and recognise only very precise circumstances in which it can be limited. For example, the European Convention on Human Rights, it gives it a very high value, which can only be restricted for the reasons which are specified in Article 10, paragraph 2 of the Convention. Any restrictions on the right to freedom of expression must be clearly provided for in law. The reasons which may be justified, which may justify a restriction under the Convention are, firstly, for national security, territorial integrity or public safety. Secondly, for the prevention of disorder or crime. Thirdly, for the protection of health or morals. Fourthly, for the protection of the reputation or rights of others. Fifthly, for preventing the disclosure of confidential information. And finally, for maintaining the authority and impartiality of the judiciary. So these are relatively precise tests. The restriction in question, as well as being provided for in law, must be both necessary and proportionate to the aim to be achieved. Necessity is a very strict test. It will only be met if there is no other means to achieve the purpose which is sought to be achieved by the restriction. The European Court of Human Rights has found that freedom of expression constitutes one of the essential foundations of a democratic society and one of the basic conditions for its progress and the development of every person. It has consistently held that speech which shocks, offends and disturbs is protected speech, not just speech which is inoffensive and which hurts nobody. The court has, for example, upheld the right of political parties to campaign for fundamental changes to the legal and constitutional structures of a state, provided that this is done through legal and democratic means, and provided also that the change sought is itself compatible with fundamental democratic principles. And if you read the case law on prohibition of political parties, which flows out of this right to information, you find a lot of them, for example, are concerned with Kurdish parties operating in Turkey and who fundamentally want an independent Kurdistan. Provided they don't use violent means to achieve this or don't propose to subvert democratic values, the court has said that that's protected freedom of speech and that they have a right to organise political parties. In the United States of America, again, freedom of speech has been afforded a particularly strong position in constitutional law. Indeed, the courts have gone so far as to uphold the burning of the Stars and Stripes as an act of free speech, which is constitutionally protected. I have to say a judgment I don't personally think makes a great deal of sense, because to me, literally, it is a very inflammatory act to, in every sense, to burn a flag. But be that as it may, that's how far they have gone. By contrast, the Constitution of Ireland gives a much more qualified right to freedom of expression. It states that the state guarantees liberty for the exercise of the following rights, subject to public order and morality, which is a very broad exception. The right of the citizens to express freely their convictions and opinions. But it then goes on to qualify this by saying, the education of public opinion being, however, a matter of such grave import to the common good, the state shall endeavour to ensure that organs of public opinion, such as the radio, the press, the cinema, while preserving their rightful liberty of expression, including criticism of government policy, shall not be used to undermine public order or morality or the authority of the state. And then it goes on to say, the publication or utterance of blasphemous, seditious or indecent matter is an offence which shall be punishable in accordance with the law. As a result of the restriction on the freedom of expression in the interests of public order, morality or state security, the constitutional protection of freedom of expression in the Constitution of Ireland is much weaker than that afforded by either the European Convention system or the United States Constitution. In fact, the Constitution of Ireland not merely permits exceptions to the right to freedom of expression, but requires the creation of exceptions in relation to blasphemous, seditious or indecent matter, and requires them to be enforced by criminal sanctions. As I suppose many members of the public learned to their surprise recently when the Oireachtas created a new criminal offence of blasphemous libel in response to this constitutional imperative. And here I note that the Constitution Review Group, which reported in 1996 and of which I had the honour to be a member, referred to the protection of free speech in the Constitution of Ireland as weak and heavily circumscribed, and quoted an observation by a writer that a guarantee of freedom of expression may have been enshrined in the 1937 Constitution, but its formulation was so qualified and ambivalent as to leave expression and information issues virtually untouched and unlitigated for several decades to come. And I would just observe that the weakness of the Irish constitutional guarantee can be measured by the fact that for the first 30 years of the Constitution's existence, Ireland had one of the most severe censorship regimes in any democratic state. So severe that indeed in 1948 they even banned a British government white paper on population control. Yet no challenge based on the constitutional guarantees was brought against that censorship regime, nor is it likely that any such challenge would have succeeded. Eventually the regime began to be dismantled in the early 1970s, but not as the result of any court action, but as the result of political pressure. The Constitution Review Group recommended major changes to the guarantee of freedom of expression in the Constitution. It argued that the test shouldn't be one of public order and morality, since that was too all-embracing. Instead, they proposed following the model of Article 10 of the European Convention, and they also proposed removing the constitutional offences of blasphemy, sedition and indecency. 13 years on, those recommendations haven't been followed. Indeed, most of the recommendations of the Constitution Review Group have not been followed. I think the only one that was in relation to the recognition of local government. And I think what this shows is that the Irish political system is not geared towards making long-term systemic change when there is no immediate or urgent problem identified. And one can speculate as to all sorts of reasons why that may be so. But one tends to find the political agenda being driven all the time by what's urgent and obviously important, and urgent things are important, but to the neglect of long-term reform, which may also be necessary and may in turn cause a problem at some point or a crisis. Just to say a little about how courts reconcile legal rights, I've already talked about the European Convention system and the way in which you have to bring yourself within one of the exceptions very clearly. In Irish constitutional law, there's a slightly different approach to the reconciliation of rights, where two rights come in conflict, although the result is often very similar. And there are two different techniques used in the Irish courts. The first is the idea of harmonious interpretation, and if possible, an attempt will be made to reconcile the rights which may appear to conflict. That's in accordance with the idea the Constitution has to be read as a whole and given a harmonious interpretation where possible. But you can't always reconcile two rights, and sometimes courts are faced with a very stark choice. And in those circumstances, the Irish courts adopt the idea of a hierarchy of rights, under which they give preference to the right they determine to be the superior right. And an example of this is a number of cases where the courts have held that the right to a fair trial is a superior right to other rights, such as the community's right to prosecute crime. If there's a conflict between the two, if the only way you can prosecute is by having an unfair trial, then you can't prosecute. I think most people would accept that as a reasonable proposition. In determining such issues, of course, the court has to have regard to the degree of interference the exercise of one right will have on another, and will take account of the actual circumstances of the case. Now, the right to freedom of expression, I think, is in a somewhat different category to other rights, because generally speaking, the act of expression in itself doesn't directly impinge on other rights or do harm. It tends to be what the expression causes some other person to do, which creates the problem. And I suggest that this may be one reason why legal systems tend to be very reluctant to permit limitations to freedom of expression. Of course, there are circumstances in which the mere act of saying something can directly impinge on another right. An example is defamatory speech, which can in itself deprive another person of his or her reputation. Similarly, it is often pointed out that there's no right to shout fire in a crowded theatre. At the very least, if you do, you'll cause alarm and panic, and at worst, you may cause injury and even death. But in most cases, the damage caused by words will come around indirectly because of what a third party is likely to do on foot of them. That doesn't necessarily mean, of course, that such matters can be permitted. For example, incitement to commit a crime is an offence even if nobody acts on foot of it. And that's because incitement to crime is regarded as sufficiently serious to amount to criminal conduct, even where it's not acted upon. There are obvious similarities and links between the right to freedom of expression and the right to carry out research or seek information. Freedom to carry out research has often been seen as a part of freedom of thought or expression. For example, the Universal Declaration on the Human Genome and Human Rights, which is a UNESCO declaration of 1997, states, quote, "Freedom of research, which is necessary for the progress of knowledge, is part of freedom of thought." Similarly, the explanatory memorandum to the Charter of Fundamental Rights of the European Union, which has recently become part of law as a result of the adoption of the Lisbon Treaty, describes the right to freedom of the arts and scientific research as being, I quote, "deduced primarily from the right to freedom of thought and expression," unquote. And in a recent case before the Belgian Court of Arbitration, they said that the principle of academic freedom had a twofold basis in the Belgian constitution, being the consequence both of freedom of expression and freedom of education. So there are certainly links. But there are also differences, and one of them, I think, is that the carrying out of a scientific experiment will often have a direct impact on something or someone else, and that is particularly so when one is dealing with the life sciences. Not surprisingly, for that reason, most of the more controversial issues in relation to freedom of scientific inquiry and research arise in the fields of medicine, biology and genetics, where specific research potentially conflicts with the right to life or with the dignity of human beings. Now, I want to just say something about constitutional and human rights protection for the freedom of scientific research. Freedom of expression is universally protected in express terms in constitutions, bills of rights, and general human rights instruments. By contrast, that's by no means the case in relation to the freedom to carry out scientific research. There is, for example, no express protection for freedom of research or inquiry or for academic freedom in the Constitution of Ireland. And given the constrained nature of the provision relating to freedom of expression, I doubt very much that one could in any way imply such a right from those provisions. But the Constitution of Ireland is not alone in that. Such a right is not expressly guaranteed in the European Convention on Human Rights, although, as I've suggested, it might be derived by implication from the right to freedom of expression there, which is not constrained in the same way as in the Irish Constitution. The earliest example of a guarantee of a right to scientific inquiry seems to be that in Article 27 of the Universal Declaration of Human Rights of 1948, which provides that everyone has the right to freely to participate in the cultural life of the community, to enjoy the arts and to share scientific advancement and its benefits. and that everyone has the right to the protection of the moral and material interests resulting from any scientific, literary or artistic production of which he is the author. But note that the Universal Declaration, while it guarantees the right to share in the benefits of scientific advancement, does not mention any right to carry out scientific investigation or inquiry. The Universal Declaration, which was a relatively short document, was subsequently expanded upon in the two United Nations Covenant, the one on the one on civil and political rights, and the one on economic, social, and cultural rights. And when they were drawn up, the right to scientific research was put into the Economic, Social, and Cultural Rights Covenant rather than the Civil and Political Rights Covenant. And effectively, Article 15 of the Economic, Social, and Cultural Rights Covenant repeated the language of Article 27 of the Universal Declaration, and in addition went on to say, the states parties to the present covenant undertake to respect the freedom indispensable for scientific research and creative activity. Now, there's an important distinction between the two covenants. The civil and political rights one is much stronger and generally contains the rights which in Western society were regarded as justiciable. And there was quite a long debate at the time between the representatives of the Western countries at the United Nations, who argued for two separate covenants, or for at least confining things to the normal justiciable ones, and the communist countries, which wanted to do things in a very different way and wanted to treat economic rights on the same basis. But the important distinction is the Civil and Rights Covenant commits the parties to full implementation from the time you ratify or accede to the covenant, and also provides a mechanism of individual complaint for countries which accede to the optional protocol. And as a result of that, any breach of a right under the covenant can be the subject of a complaint to the Human Rights Committee, which can deliver an opinion against the state concerned. By contrast, the Economic, Social and Cultural Rights Covenant merely has a reporting arrangement under which each state has to report every 2 or 3 years. And also, the rights in it are ones to be attained progressively. It's not expected that they will be immediately enforced. Looking at constitutional protection for freedom of scientific research and inquiry, again, Ireland is not the only country with a constitution that doesn't provide this. Most European countries whose constitutions date from before 1948, and some which are later, similarly have no such provision. They include Belgium, Denmark, France, Germany, the Netherlands, Norway, and Sweden. But constitutions adopted more recently tend to contain a provision guaranteeing rights to scientific research as well as artistic endeavour. The first is the Italian constitution adopted in 1948, which says the arts and sciences as well as their teaching are free. The Spanish constitution adopted in 1978 guarantees the right to literary, artistic, scientific and technical production and creation, as well as the right to academic freedom, and that provision is contained in the same article which protects freedom of expression and communication. Almost all of the constitutions adopted in the emerging democracies of Central and Eastern Europe after the collapse of communism guaranteed the freedom of artistic creation and scientific research, as well as the right to benefit from the achievement of scientific progress. Many of them also guaranteed the autonomy of universities and institutions of higher education. I'm not sure why things developed in this way after 1948, but I suspect it was because in the wake of the Nazi experiments, one had to limit to some extent freedom of scientific research, and therefore one also had to assert as a principle that there was such a thing. Before that, I think constitutions were silent on it because nobody questioned it, perhaps. Be that as it may, 1948 seems to be a sort of cut-off point after which you find constitutions guaranteeing this right. The Charter of Fundamental Rights of the European Union has followed the tendency of recently drafted national constitutions, and it says the arts and scientific research shall be free of constraint. Academic freedom shall be respected. So, moving on then, I just want to say a little about abuses of scientific research, because I think that's largely what brought about the development of a lot of these instruments and people looking at these questions of ethics and in relation to research. And there have been many occasions in the past when shocking abuses of human rights were carried out. The worst examples, I think, are well known. They include the atrocities carried out by Dr. Mengele and others in the concentration camps in Nazi Germany under the guise of medical experimentation. And I won't attempt to describe any of them. There is a lot of literature on the subject. Another example of something that happened was the experiments by Professor Ilya Ivanovich in the USSR around the early 1930s, where he attempted to interbreed humans and chimpanzees, not with any success, but there were a lot of dead chimpanzees at the end of it, I think. But these abuses of human rights were by no means confined to totalitarian states, and the most infamous example perhaps is the so-called Tuskegee study of untreated syphilis in the Negro male. And that was a study which concerned 616 African-American men who were all given blood tests in 1932. 412 of the people who were in the study had syphilis, and the others did not. They were controls, so to speak. The test subjects were not told they had syphilis and were not treated for syphilis, despite the fact that after 1943 penicillin was available as a cure. At that stage, the study had been running for 11 years. The purpose of the research was to study the long-term effects of untreated syphilis. To the shame of the American medical community, it seems that most of the leading venereologists in the United States at the time were aware of this experiment and saw no difficulties with it. And the research was discontinued only in 1972, 40 years after it began, after a journalist reported on it. So what all these examples of human rights abuses have in common, and the core issue for them all, was that they were carried out on the subjects of the experimentation without their consent. Now, I've already mentioned the Nuremberg Code, which, as I say, arose from the evidence which was given at the doctor's trial in Nuremberg, and which attempted to formulate principles under which medical experimentation should be carried out. And the core principle was that there should be no experimentation without the consent of the subject. There were quite a number of other principles elaborated too, but that was really the central and most important one. And it emphasised the requirement for voluntary consent of the human subject of research and the weighing of the expected benefits of research against the risk to participants. Then later there was the Declaration of Helsinki of the World Medical Association, first adopted in 1964 and updated on a number of occasions since. And this set out ethical principles in relation to human experimentation and is regarded as the ethical cornerstone of biomedical research in human subjects. In the United States, after the Tuskegee case came to light, the US Congress created a National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research, and it published ethical principles, generally known as the Belmont Report, in 1979. 3 general principles were identified by them: respect for persons, and particularly those with diminished autonomy; the principle of doing no intentional harm while maximising the benefits and minimising the risks of the experimentation; and the fair distribution within society of risks and benefits. For example, that you do not carry out research among that part of the population who can't benefit from the research. So those have really been the foundation of what has come after that. Now, on the subject of consent to medical research, I mentioned the International Covenant on Civil and Political Rights, but it contains, while it doesn't contain a right to scientific research, it does contain a provision in Article 7 prohibiting the carrying out of scientific or medical experimentation on human beings without their consent. And that, of course, is the covenant which has the right of individual complaint. Again, this provision is commonly found in recent national constitutions. Article 3 of the Charter of Fundamental Rights of the European Union provides, among other things, that in the field of medicine and biology, the free and informed consent of subjects must be obtained. The question of consent to medical experimentation is also dealt with in 2 international human rights instruments that aim to protect people against the misuse of medical and biological advances. They are the UNESCO Universal Declaration on Bioethics and Human Rights adopted in 2005, and the Council of Europe Convention for the Protection of Human Rights and Dignity of the Human Being with regard to the application of biology in medicine. This was adopted in 1997 and is generally referred to as the Oviedo Convention, and I will refer to it as the Oviedo Convention from now on because the full title is far too long. The UNESCO Declaration provides a universal framework. It doesn't have direct effect in states. It's a universal framework of principles and procedures intended to guide states in the formulation of their legislation, their policies, or other instruments in the field of bioethics, and it sets out a number of general principles. It starts by saying human dignity, human rights, and fundamental freedoms are to be fully respected. The interests and welfare of the individual are to have priority over the sole interest of science or society, which is a very important statement of principle, I think. The fundamental provision in relation to consent is that any preventive, diagnostic and therapeutic medical intervention is only to be carried out with the prior, free and informed consent of the persons concerned, based on adequate information. And where persons don't have the ability to consent, authorization should be obtained in accordance with the best interests of that person. People should be free to withdraw their consent at any time. That again is an important principle found in all of these instruments. Research should only be carried out for the direct health benefit of the person who cannot consent, and if there is no research alternative of comparable effectiveness with research participants who can consent. Research which does not have potential direct health benefits should only be undertaken by way of exception, with the utmost restraint, exposing the person only to a minimal risk and minimal burden. I think that provision is rather unspecific and not clear to follow what exactly it means. The Declaration also provides that benefits resulting from scientific research should be shared with society as a whole and with the international community, in particular with developing countries. The Oviedo Convention contains similar principles to the UNESCO Declaration. Again, it's an important instrument on human rights and biomedicine. Many of the member states of the Council of Europe have ratified the Convention, although quite a number have not, including Ireland, which is not yet a party to it. The Convention's starting point, again, like the other one, like the UNESCO one, is the concept of the dignity and identity of all human beings. It contains provisions very similar to the UNESCO Declaration, and I won't refer to them, particularly in relation to consents and the procedures to be followed where persons cannot consent. It does have a different provision which says where the research does not have the potential to provide direct benefit to the research subject's health, it may be authorised where it has the aim of contributing through significant improvement in the scientific understanding of the individual's disease or disorder to the ultimate attainment of results capable of conferring benefit to the person concerned or to other persons with the same disease or disorder, and only where the research entails minimal risk and burden for the individual concerned. So it's rather more specific than the UNESCO Declaration in the conditions under which research can be carried out on subjects who can't themselves benefit from it. On the 4th of December 2002 in Shanadairn, the then Minister of State at the Department of Health and Children, Mr. Ivor Callally TD, explained that Ireland was not a party to the Oviedo Convention, and I quote from him, "Because there are difficulties with a number of articles that have implications for the destruction of human embryos," unquote. He didn't specify what articles were in question, but he did go on to state as follows: "I'm deeply concerned about the absence of statutory controls in regard to a range of interventions in the sphere of assisted human reproduction, including that of human cloning. While medical practice in the area of reproductive medicine is governed by Medical Council guidelines, these only apply in the case of registered medical practitioners and would be ineffective in the case of any service provided by other persons." Now that we have the benefit of detailed work from the Commission on Assisted Human Reproduction, as well as the advice of the Irish Council for Bioethics, which has issued a number of very valuable and detailed reports, it's important, I think, that progress should be made towards implementation of the Oviedo Convention, and if necessary with reservations or declarations. In the absence of such implementation, many areas of scientific research remain unregulated, with the exception of the area of clinical trials. Outside of that area, there is, on the one hand, no effective regulation of the unscrupulous researcher who is not subject to medical ethics, while on the other hand, there is the problem that the absence of proper regulation leaves the legal situation unclear and exposes the bona fide researcher to possible legal action by private bodies of citizens. I'm not going to say much about clinical trials except just to mention that there is legislation. It's regulated by European Community directives, and I just mentioned this for completeness, and they've been transposed into Irish law. They cover investigations which are undertaken to ascertain the efficacy or safety of medicinal products in human subjects. Then there are also non-interventional trials involving licensed medicines that are used within the terms of the licence, and they're governed by the Control of Clinical Trials Acts of 1987 to 1990. The regulations provide for a regime of approval of clinical trials by ethics committees, as well as detailed rules requiring consent of subjects who participate in clinical trials. There are conditions and principles for the protection of subjects capable of consenting, subjects incapable of consenting, and subjects that are minors. The regulations, and I should say these principles, are fully in accordance with the Oviedo Convention and with the various principles that have been laid down. But of course, clinical trials does not cover the entire field of medical experimentation by any means. The regulations state that clinical trials are to be conducted in accordance with the ethical principles set out in the Declaration of Helsinki, and that the rights, safety and well-being of the trial subjects are to prevail over the interests of science and study. And these regulations now extend to tissue-engineered products, as well as what would be thought of as products in the more normal sense. I just want to say a little about the human genome. Again, this is an area which is not regulated in Irish law, but on which there is a wealth of international instruments which we could look at. Genetic science has undergone dramatic changes in recent years. The developments include genetic testing and gene therapy. Genetic testing consists of medical examinations aimed at detecting or ruling out the presence of hereditary illnesses or predisposition to such illnesses by directly or indirectly analysing the genetic heritage of an individual. It is now possible to identify with much greater precision than ever before those who carry specific genes for major single-gene disorders such as cystic fibrosis, haemophilia, Huntington's disease, as well as those who carry genes which may increase their risk of developing major disorders later in life, such as heart disease, cancer, and Alzheimer's disease. It is also possible to identify genes which, while they are not responsible for single gene disorders, nevertheless contribute to the development of major disorders. In some cases, testing may offer the possibility of timely preventive treatment or the opportunity to diminish risks through modifications in lifestyle or environment. However, in other cases, knowledge of a genetic problem will not necessarily mean that there is a solution to be found. For this reason, the right not to know can sometimes be as important as the right to know. This also gives added importance to the right of free consent. A further complicating factor is that genetic testing may have implications not only for the individual, but for his or her relatives. It may be that a gene, for example, is going to be shared with various other members of the family. For all these reasons, it is important to limit the applicability of predictive testing to cases where this can be used for the benefit of the health of the subject of the testing. It is also important to ensure that health testing for the benefit of third parties, such as insurance companies, as distinct from health testing for the benefit of the subject, is prohibited. An insurance company should not be entitled to subject the decision whether to issue an insurance policy to the holding of a predictive genetic test, nor should an employer be entitled to require a potential employee to undergo such a test. And these are not just opinions I'm expressing. These arise from the UNESCO Declaration and the Oviedo Convention. And the Oviedo Convention specifically says predictive testing can be used only for health or scientific research, by implication ruling out its use for employment or insurance purposes. Again, I'm not aware that we have any legislation dealing with those issues in Ireland. If there is, I haven't been aware of it. The Oviedo Convention contains a number of provisions relating to the human genome. Article 11 of the Convention prohibits any form of discrimination on grounds of genetic heritage, and again, this has relevance to questions such as insurance or employment. The Convention states that any intervention seeking to modify the human genome may only be undertaken for preventive, diagnostic or therapeutic purposes, and provided its aim is not to introduce any modification in the genome of any descendants. Also under the Convention, the use of techniques of medically assisted procreation are not allowed for the purpose of choosing a future child's sex, except where serious hereditary sex-related disease is to be avoided. Again, I don't think there's any Irish legislation to that effect. In 1997, UNESCO adopted a Universal Declaration on the Human Genome and Human Rights. Its point of departure, again, is the dignity of the human being. The human genome is described as underlying, and there's an unfortunate misprint. I have copies of the paper for anyone who wants them at the end. There's an unfortunate misprint where the word undermining appears rather than underlying in the paper. But it's described the genome as underlining the fundamental unity of all members of the human family, as well as the recognition of their inherent dignity and diversity. It is described in a symbolic sense as the heritage of humanity. The Declaration proclaims everyone's right to respect for their dignity and their rights, regardless of their genetic characteristics. Human dignity makes it imperative not to reduce individuals to their genetic characteristics and to respect their uniqueness and diversity. The Declaration includes principles on prior informed consent, confidentiality of data, reparation, protection of public health, benefit sharing and international cooperation. Then I turn to the question of cloning. Reproductive cloning means the creation of an organism that is a genetic copy of another existing organism, and there have been successful clonings of various animals, including cats, dogs, cows, horses, deer, pigs, rabbits, and of course sheep. The technique has been described as highly inefficient, as there's less than a 1% chance of obtaining a live birth, and also unpredicted problems have arisen in all of the mammals cloned so far, leading to a high rate of fetal abnormalities and prenatal death, and to health problems of those animals born alive. That's not to say that the techniques won't be improved in such a way that those difficulties are eliminated at some stage in the future. Article 3 of the Charter of Fundamental Rights of the European Union prohibits the reproductive cloning of human beings, but of course the Charter is addressed only to the Union and not to the individual member states. The UNESCO Declaration on the Human Genome and Human Rights provides in Article 11, quote, practices which are contrary to human dignity, such as reproductive cloning of human beings, shall not be permitted. The Council of Europe has adopted an additional protocol to the Oviedo Convention prohibiting the cloning of human beings. The protocol notes that the cloning of human beings may become a technical possibility, but considers that the instrumentalization of human beings through the deliberate creation of genetically identical human beings is contrary to human dignity and thus constitutes a misuse of biology and medicine. And it also refers to the serious difficulties of a medical, psychological and social nature that the deliberate cloning of human beings could imply for all of the individuals involved. For these reasons, the protocol to the Oviedo Convention prohibits any intervention which seeks to create a human being genetically identical to another human being, whether living or dead, but adherence to the protocol is open only to parties to the Oviedo Convention. That, of course, would not stop a state itself from introducing its own domestic law to prohibit reproductive cloning, but we have yet to do so. I just turned to the subject then of stem cell research and the use of human embryos, and this, I think, raises the most difficult ethical and legal problems which exist at the moment in the field of scientific research. Now, I have to make it clear, I'm not a scientist again, and it's obvious that I'm not, and so I can't describe all the amazing developments that have been happening over the last few years, and I won't attempt to do so. But I would recommend anyone who's interested in the area to read the Irish Council for Bioethics opinion on ethical, scientific and legal issues concerning stem cell research, and I've given the website, I think, there for anyone who's interested. It's a fascinating read, and what I'm saying is just culled from it in a very simplified way. Briefly, the report explains that stem cells are immature cells from which all specialised cell types can be derived. I think there are about 200 different types of cells in the human body, but any of them can be got from the immature stem cells. There are two basic types of stem cell, adult stem cell and embryonic stem cells. Sorry, when I said all types, they can be derived from the embryonic stem cell. Adult stem cells are found in various sites in the body, such as bone marrow, the brain, blood, the eye, the liver, etc. Generally speaking, adult stem cells have a relatively limited capacity to turn into more specialised cells. For example, the adult stem cells found in blood can transform into the various different blood cells, but not into, for example, skin cells, and so on. Embryonic stem cells are the cells found in the developing embryo at a very early stage of development and have a capacity to develop into any of the different cell types, as I mentioned. They begin to specialise as the embryo develops into a fetus. Stem cells can be isolated and used to generate lines of stem cells in the test tube. These have potentially huge implications for medicine. Potentially, they can be used to replace and repair diseased cells in the human body and are therefore of potential value in all illnesses and disorders characterised by diseased or damaged cells. The ethical and legal questions relating to stem cells arise in relation to embryonic stem cells. There's no particular ethical issue or indeed legal issue, so far as I'm aware, arising in relation to the use of adult stem cells. Adult stem cells, incidentally, is a misnomer. It's not just adults, it simply means stem cells found in a developed creature rather than simply at the stage of the embryo. The characteristics of embryonic and adult stem cells differ. Embryonic stem cells are not only more versatile in their potential development, but are capable of multiplying much more rapidly than is the case with adult stem cells. On the other hand, the risks attached to rejection in the case of transplanting cells are less for adult stem cells than they would be for embryonic stem cells. And potentially in the future, a diseased person's own stem cells could be used to create stem cell lines and thereby avoid the risk of rejection. The technology in this area is advancing very rapidly, and there is a possibility, for example, that adult stem cells may have the potential of being de-differentiated, in other words, turned into stem cells at an earlier stage of development, which would be capable of being developed into a greater variety of cell types. This all gets very complicated, but essentially the Irish Council for Bioethics report points out that there's an emerging consensus among stem cell researchers that a continuum of stem cell types exists, with fetal stem cells, for example, lying somewhere in between embryonic and adult stem cells in terms of their ability to transform into a variety of specialised cell types. The report points out that at present it is very difficult to predict which type of stem cell might be most successful in treating various diseases and conditions, and concludes that many scientific bodies converge on the view that research using all types of stem cells, including human embryonic stem cells, represents the optimal strategy for the advance of stem cell research and the delivery of therapies. The ethical and legal questions in relation to the use of embryonic stem cells arise, of course, from the question of what moral value we ascribe to an embryo. The embryos which are used in stem cell research are the surplus frozen embryos, which arise as a byproduct of assisted human reproduction. If not used in stem cell research, they would either be frozen indefinitely or destroyed. There are those who believe that full moral value should attach to life from the moment when the sperm fertilizes the ovum, and that the resulting organism, starting with 2 cells and dividing into 4, 8, and so on, has already the moral quality of a human being. Persons who hold this view believe that any act which is carried out and results in the destruction of the embryo and its ability to progress on the path towards birth is morally unacceptable, and this view would be held even where the fertilization has taken place in a test tube and the embryos are frozen at an early 16-cell stage. On the other hand, there are others who do not ascribe such a moral value to an 8 or 16-cell embryo resulting from in vitro fertilization and consisting entirely of undifferentiated stem cells, and which does not have a nervous system or any ability to perceive anything or feel pain, even though if implanted in the womb it would have the potential to develop into a fetus and eventually be born as a human body. And as we're all well aware, people have very strong opinions and very deeply divided opinions on this issue, and I think this is largely what has prevented legislation in this area to date. The legal issue arises because of the constitutional protection given to the unborn as a result of the 8th Amendment to the Constitution in 1983. Unfortunately, there's no definition within the Constitution of an unborn, nor despite a number of judicial pronouncements has the Oireachtas attempted to define it by legislation. Even if it were permissible to examine the question by reference to what was stated at the time of the referendum by those who put forward the amendment, a process which I think is not admissible from a legal point of view, one would still find quite a variety of opinion. There's no doubt that many of the proponents of the amendment were strongly of opinion that life begins at the moment of conception, and that that is precisely what they wanted to protect, and that is what they meant by the unborn. At the same time, there were those who denied that the effect of the constitutional amendment would be to render unlawful the morning after pill, which, if they were correct, must mean that unborn doesn't refer to pre-implantation embryos. Be that as it may, and that's really a matter of speculation, but I think it is quite unclear to a lot of people exactly what was meant. And the legal position remains unclear. In a recent decision of MR v TR and the Attorney General, the High Court declined to hold that the word unborn in Article 40(3)(3) included embryos outside the womb or in vitro. The case was one concerning a dispute between an estranged husband and wife over the status of 3 frozen embryos which had been created by in vitro fertilisation. And Mr. Justice McGovern stated as follows: "It is not for the courts to decide whether the word unborn should include embryos in vitro. This is a matter for the Oireachtas or for the people in the event that a constitutional amendment is put before them." In 2000, the government established a commission on assisted human reproduction to make recommendations in the area of in vitro fertilisation practices. In March 2005, the commission published its report, in which it made 40 recommendations, most of which were unanimous. A majority of the Commission recommended that the embryo formed by IVF should not attract legal protection until placed in the human body, at which stage it should attract the same level of protection as the embryo formed in vivo. It is a matter for the Oireachtas as to whether they implement the recommendations of the Commission. In the meantime, the courts are being asked to deal with a complex dispute involving social issues which should be governed by a regulatory regime established by an Act of the Oireachtas. I believe this case is currently under appeal, and if I'm right about that, the decision of the Supreme Court on the point will be awaited with great interest. In the 2008 report of the Irish Council on Bioethics, which I've already recommended for its description of what's happening and also its analysis of the legal situation, in one of the conclusions to its report, which is strongly worded, I think, they said as follows: "It is the view of the Council that a failure to provide a comprehensive and cohesive regulatory system to govern stem cell research and its applications undermines the moral value of the human embryo. It may also hinder developments in this field of research in Ireland. Thus, the Council recommends the establishment of a state-funded regulatory authority which would function independently and transparently in its principles and agenda to oversee embryo research. Such an authority should be tasked with the registration, licensing and inspection of persons, premises and activities working with human embryos and/or embryonic material. Furthermore, the authority should develop codes of good practice for professionals working in the area and provide accessible information for the public. The European Union has established a European Group on Ethics in Science and New Technologies. Their task is to examine ethical questions arising from science and new technologies, and on this basis to issue opinions to the European Commission in connection with the preparation and interpretation of community legislation or policies. In an opinion which they published in November 1998 entitled "Ethical Aspects of Research Involving the Use of Human Embryos," the EGE stated that the human embryo deserved legal protection and that such protection fell under the remit of national legislation. The EGE recognised the difficulty of standardising such legislation throughout individual member states and acknowledged that it would be inappropriate for the EU to impose one exclusive moral code. In Ireland, public funding has been restricted to adult stem cell research. However, the Irish government has adopted the position that European funding for embryonic stem cell research will not be permitted in Ireland, but it has not sought to prevent the EU providing funding for research in those countries where it is permitted. So that brings me to my conclusions. And the basic message I'm saying is, first of all, the Constitution of Ireland provides for the right to freedom of expression of convictions and opinions, but the qualifications it permits have the result that the constitutional protection of freedom of expression is relatively weak. The proposals of the Constitution Review Group in 1996 to strengthen the constitutional guarantees have not been acted upon. I don't think one could imply any right to scientific research from the right to freedom of expression in the Irish Constitution. The right to scientific research is not referred to in the Constitution of Ireland, but is recognised in the EU Charter of Fundamental Rights. Clinical trials are regulated by legislation and medical doctors are bound by a code of ethics. But in the important area of biomedicine, there is otherwise an absence in Ireland of regulation. Ireland is not yet a party to the Oviedo Convention or its protocols in this area. Furthermore, despite the constitutional protection given to the unborn, there has been no legislation to give it effect or define its scope. Consequently, questions remain concerning the legality of various avenues of scientific research, and the absence of legal regulation is likely to act, on the one hand, as an inhibition toward the genuine researcher, without, on the other hand, imposing a clear prohibition on techniques such as reproductive cloning, which it is generally agreed ought to be permitted. So that concludes what I want to say, and I thank you very much for your attention.
I would like to thank Mr. Hamilton for his excellent review and overview of the legal and ethical problems, and I think for crystallising the fact that many people in Ireland, both from the patient's point of view and also from the professionals trying to help them, are working in this vacuum, and it is very, very difficult. And I was just wondering, before I open the discussion to the audience, is just how you can use the Charter of Fundamental Rights, for example, to maybe push the politicians into doing something, or are we stuck?
I'm not sure that you can very much, because it's addressed essentially to the community institutions, so it means obviously that the council or the commission can't act in a manner which is inconsistent with it. But I don't think, unless the court in Luxembourg develops the jurisprudence in ways that one can't anticipate, I don't think it gives any power to impose a duty on the member states to act in that way. And indeed, the community has itself accepted on a number of occasions that certain issues, such as the stem cell research one, are matters for individual states to decide. But insofar as something, I mean, if somebody were to set up human cloning in Ireland, well, I imagine there might be legislation fairly quickly at that point, but it would be in a crisis situation. I don't know whether they would treat that differently because it's universally prohibited and everybody agrees that it should be unlawful. So I don't know whether the Charter could be used in some sort of way indirectly to deal with it. I don't know, that's not really my area of expertise, I'm afraid.
Any questions? The other thing was more of a comment. I would actually disagree that there aren't ethical issues with adult stem cells when I'm talking about, because one of the things I think that is coming out, that perhaps, and it is great, that embryonic stem cells may not be necessary. As you say, it may be possible to induce these cells, still in a research process, but it does have the ethical thing that you are asking people to donate for other people. For example, we have a bone marrow registry, and there are something like 13 million donors worldwide who are tissue typed and are prepared to give their bone marrow to patients who need a bone marrow transplant, and that's well established. It's been going on since the late 70s, early 80s. But what is also recently now is, are they going to be asked to give stem cells for repair of myocardial heart attacks, neurological disorders, etc. And these techniques, getting the actual donation is not without some possible harm for the donor. And while you can address it by informed consent, as doctors we often wonder whether people can really be informed consent ahead of time and what actually happens when something goes wrong, particularly when you're dealing with a volunteer.
Yeah, I'd accept that. I think I phrased things. I should, instead of saying there was no particular ethical issue arising in relation to adult stem cells, I think I should have said there's no ethical objection to their use. But of course, all the issues about consent and about the use of things for somebody who can't benefit and so on would arise, and the issues that you've referred to, of course, are there. I just mean that there isn't a moral objection fundamentally to it in the way that a lot of people have to use of embryo stem cells.
Yes?
I have a question. It might sound silly,
Do
when you change these, it's scientific as well, when you change these adult stem cells so that they can be used in a similar amount to embryonic stem cells, does that not bring up some kind of question, possibly, are they not now considered the same as those embryonic stem cells, and are they not now put into the same category? From them, could you not grow potentially a child in a human being?
Well, I think if you went to that stage, you would be entering into the cloning area. But I think what you're doing in the sort of thing I'm talking about is there are this small population of cells, particularly in placental blood and umbilical cord. You can find them, and these cells could be used, and they would be a perfectly acceptable and alternative way of dealing with this problem, because I think a lot of us do have this issue of using embryonic stem cells, even if they are surplus, because I think what's happening now is they're tending perhaps to freeze, because the success rate is increasing, there won't be so many of them. So then you might be talking about actually creating embryos for research, and I think a lot of people would have trouble with that.
I think the Oviedo Convention specifically prohibits the creation of embryonic stem cells for research. So that again in Europe seems to have been the approach. Your question also in the Council for Bioethics report, there's a very interesting example similar to the one you mentioned of the suggestion, for example, that if you take an 8-cell embryo and you just take one of the cells out, leaving it as a 7-cell embryo, which would then be capable of developing into a human being if it was implanted and so on, and it could do so without the missing cell. And then you use that one cell to develop a stem cell line. Is that okay? But then other people say, well, yes, but what if that one cell could itself then turn into 2, 4, 8 and become another human being? So you can see that the complications from an ethical point of view, if you have the view that you can never go near cells in that state, if they have the potential to form a human being under the right conditions, you can see the difficulties arising. They really, I mean, they're essentially ethical, philosophical and religious in many cases problems, I think, rather than scientific questions. But the choice as to whether you can do this or not is essentially an ethical and philosophical and religious question.
Yes?
What about going back to the freedom of inquiry side of things? In countries that are perhaps governed or aren't signed up to some of these conventions, etc., where data are produced perhaps on something, and in terms of the Irish situation, I mean, how do we stand with regard to actually use of that data to theorise on the matters here, and what are the, certainly there are ethical implications, but legally, kind of, can we theorise but not experiment, you know what I mean?
I wouldn't see any legal objection. I'm not saying somebody wouldn't try to formulate one, but provided you don't interfere with any actual life, I can't see that there would be a legal objection to that.
But if
somebody might say if it's going to be used then by somebody in another jurisdiction, they might try to prevent it on that basis, I suppose. Again, all of this is really an area that just has not been litigated. Because of the absence of law, it's very difficult to predict how a court would react. But to date, certainly, when asked to look at the whole question of human embryos and whether they're protected under the Constitution, our courts have been reluctant to do this, given that the Oireachtas, they have, on more than one occasion, I think judges have expressed the view that the Oireachtas should legislate and should deal with the issue.
Would you agree that until we can definitively say when human life begins that we shouldn't use embryonic research? Because I believe you said, forgive me if I'm wrong, that a commission found that life doesn't, or that you can use an embryo until it has been implanted in a human. But I don't see, like, what process did they use to draw that conclusion? Because it doesn't seem that there is a definitive way we can say when human life begins.
I don't think this is a scientific question. I think it's a moral, ethical question.
Yeah.
I mean, look, you know, there are arguments both ways. There are certainly people who say if you do anything at all once you have a fertilized egg, you're on a slippery slope. And then there are other people who would say you're actually on a gradual progression. And there is I mean, some people would say the qualitative difference when the embryonic cells start to develop into differentiated into cells that have a specific purpose. And that's the start of the process whereby you end up with a nervous system, with skin, with organs, with sight, with thought, and all these other things. But before that, you only have the potential. So you can argue it either way, but I don't think it's a scientific question, because the scientists can explain to you exactly what the position is. It's really a moral and ethical question to decide what value you ascribe to what you're talking about. And that's the problem. There are very different views on the subject.
Yes.
Sorry, the awfulness of the Nazi experiments and the polarization of views on abortion have led to some fairly clear expressions of views on those areas. But one is aware in both the United States and in Australia and in other countries of experiments that were more social and psychological rather than medical. Has anyone considered the ethics of those? Separating children at birth to see how they develop, taking children from one race and putting into another to see how they develop, and so on.
I couldn't answer that.
Well,
I mean, I'm sure people have.
yes, I think that people realise that a lot of what was done in the past was absolutely unacceptable. While you were talking, I was thinking about that there was one particular, not the Tuskegee study, but the Bellevue Hospital study, which was where children were put into an institution, mentally retarded children, or mentally, and because of the horrendous conditions in it, all of them got hepatitis. And they had found that if you gave people gamma globulin, you could protect them from hepatitis. But they actually went and did an experiment where they deliberately fed some of the children with material that was contaminated with hepatitis. And then some of them got the gamma globulin and some of them not. And it was also complicated by the fact that there was coercion. You didn't get into Bellevue if you didn't accept the thing. And all the stuff around it was wrong. And that, I think, is one of the, that came out probably about the same time as the Tuskegee study. So I think it made a huge difference to how people perceive. So yes, it's not just what you do, but social ones as well are unethical, those kind of things.
I mean, they should be unacceptable, of course, but to what extent the particular professions have regulated themselves, I don't know. But for example, in the instruments dealing with the human genome, they all emphasise the psychological damage that can be caused. And I mean, you can imagine, for example, what a strange world it would be if we had hundreds and hundreds of Einsteins cloned and hundreds of Marilyn Monroes. And you know, I don't know how the rest of us might feel about all of that, or what sort of a world you would end up with if people could pick and choose in this way and arrange to clone people who had particular qualities and so forth. And I think that's where, you know, they emphasise things like the social and psychologically harmful effects. So obviously there is an interest, but I'm not aware of any instruments on this sort of importance and level in other areas which have been brought about other than the ones relating to medical experimentation and bioethics. But I agree with you, yes, these are areas that should be dealt with as well. And they do have potential. And the other thing that has obvious future potential, I suppose, is brain science. Where, I mean, for example, if you have a possibility to change personalities through brain surgery or do something like that, that would raise very obvious ethical problems as well.
I think there's, yes?
Sorry, if I might go forward a few years, having taken the opportunity of brain surgery, the heart transplant, skin grafts, and perhaps a touch of cloning, at what stage will I be refused citizenship?
Yes?
If we ban certain procedures as being unlawful or unethical, but the research is carried out elsewhere where there are people who don't have our sensibilities, and we later benefit from the discoveries that they make, cure our horrible diseases without ever having laid our own hands on an unwilling subject. Could you say that the whole thing is a sort of choreograph affair where the law offers patchy protection to some people at some times, but can't prevent, or perhaps even shouldn't prevent, the good things that come from bad practices?
Well, I mean, that's a point that's frequently been made, and a lot of people would hold that quite strongly. But in fact, when you think about it, there are very few people who actually really do practice, everything like this, and will refuse the fruits of something they may not approve of. I mean, an obvious example is electricity, which is produced from nuclear power. I mean, if you're visiting the UK, I don't know how much of our electricity, by the way, is coming from nuclear power. I'm sure some of it is. If you visit the UK, you won't refuse to turn on the switch, I suppose, because they're contributing, maybe using electricity that even it comes from Sellafield. The only people I know of who try to make a conscious effort to avoid the 20th century are probably people in Pennsylvania. It's Pennsylvania Dutch who still ride around in the horse and buggy. So yeah, that's a genuine problem, of course.
Well, if there are no more questions, perhaps it just remains to me to, on behalf of the audience, to thank you very much for a very stimulating lecture. Thank you very much.